encashment is concerned, the calculation is to be done by the Office of Learned Advocate, Accountant General. And so far as DPF is concerned, some more time is required to comply the sale order. We have submitted that the records of the petitioner is with CBI.
For certain period.
Records of CBI of the petitioner is with CBI so far as it relates to certain period, due to which the calculation could not be done. A copy of the said letter has been provided to Mr. A.K. Singh, advocate. Abhi then so that he may seek instructions. And if the calculation is to be done by the Office of Accountant General, the needful be done at the earliest, so that the admissible amount is paid to the petitioner. Post on 30th October. इसको लगा दीजिए, इसको रिकॉर्ड में रखिए।
और मेरा बहुत दिक्कत है इसको गिरनी है लेकिन थोड़ा एकदम डार्क है पूरी तरह, उनको नजर नहीं आ रहा है। हम भेज देंगे।
ठीक है, चलिए।
Passover case item 1, second April 57 of 1998.
Application has been filed for substitution of referendum number 3.
Any objection?
4A. Yes. So far as death of one of the appellant is concerned, we do not have much objection. And 3. But one of the appellant is concerned, it is 521 days delay.
Yes.
So there is abatement and there is no sufficient cause explained in the interlocutory application. So far as the delay is concerned, the death 4A, death was on 1/9/2023, paragraph 6, and they also admit subsequently themselves in para 7, one explanation given due to communication gap. Then para 8, they admit that it was on 24/6/24 the information was received. Even then, from that day, there is delay of more than a year. So far as 3 is concerned, we do not have much objection, though it has abated, but it is period of 50 days.
They have said that on 24/6 it was provided, and thereafter the court adjourned the matter. Right?
Adjourn the matter, but they have not filed it, and it has been filed now. It has been filed on 11 August 2025.
You want to respond to this?
So far as factual aspect are admitted, date of death are aspect. On issue of law only, we will just try to assist.
No, there is no question of assistance. अभी तो substitution है, एक आध साल बाद रख देते हैं।
On this part,
You will have to file a response to this. आप counter affidavit file करें। Counter affidavit file करने का आपको time to this petition.
because we were only relying upon the recent.
There is no problem. You
Suresh
just-
Chandra judgment, because
You file a counter affidavit.
it amounts to abatement of the appeal,
That's it.
and that has
You
to
file a counter affidavit to this. Right? IE number 10815.
within a week we will file the.
That I will give you time enough. In essay number 57 of 1998. This petition has been filed for substitution of appellant number 4 within bracket A and also appellant number 3, both of whom died during the pendency of this case. With respect to appellant number 3, the learned counsel for the respondent has no serious objection. But with respect to appellant number 4 within bracket A, he submits that there is no proper explanation and there is a delay of 521 days. The response to the interlocutory application be filed by 23rd of December post on 2nd of January 26. You take your time.
I'm just praying that 1 week and then.
कोई बात नहीं, आपके अनुसार टाइम नहीं होगा. अब पुराना मैटर है चाहे जो भी है, अब आप अगला बेंच में अगले साल
We are not praying for much time. Then let it be heard, let the substitution be allowed and let it be heard right now. We are reading merits. Let it be heard on the side.
चलिए नहीं ऑर्डर कर.
Because I was going through recent Suresh Chandra judgment, and so I thought that.
You see, please appreciate the matters are pending before this.
No, let it be heard.
98 से केस चल रहा है, ठीक है. अब एक सब्स्टिट्यूशन हम यहाँ रिजेक्ट कर दें, फिर वो चल जाए सुप्रीम कोर्ट, फिर अगला 20 साल तक ये केस टेकअप नहीं.
ठीक है, बस खाली एक ही प्रेयर करें.
देखिए कॉज ऑफ एक्शन सर्वाइव्स, ठीक है.
खाली एक ही
जॉइंट कॉज ऑफ
खाली
एक्शन.
यही सबमिशन हम लोग का उसमें लिखा दीजिएगा, जहाँ अलाउ कीजिएगा, बस ये चीज़.
We substituted legal error 4A. In fact, 4 who died, then he was substituted by 4A and B.
Ultimately, तो
Ultimately, 4A.
मिस्टर बैनर्जी, हम लोग का अभी टारगेट ये है कि पुराने केसेस को करना है. एंड आई नो यू मस्ट बी अंडरस्टैंडिंग हाउ डिफिकल्ट इट इज टू टेक अप ओल्ड मैटर्स. ठीक है, रिकॉर्ड भी नहीं पढ़ सकते हैं, स्कैन नहीं हो सकता है, और पार्टी को तैयार करना ही मुश्किल है. बस यही मनाते हैं कि आदमी कोई मर ना जाए. ठीक है,
that is true.
लिखिए, फिर से लिखिए. आइए नंबर 10815 of 2025 in essay number 57 of 1998. This petition has been filed for substitution of appellant number 3 and also appellant number 4A, who have expired during the pendency of this case. There is a delay in filing the petition for substitution with respect to 4A, which is to the extent of 521 days. The learned counsel for the appellant has submitted that the matter has remained pending before this court since the year 1998, and earlier appellant number 4 expired, who was substituted. Now 4A has also expired. The learned counsel has further submitted that the substitution be allowed. He has also submitted that other legal heirs and successors of respondent number 4 are already on record, who are 4B and 4C. He has submitted that the legal heirs and successors of 3 and 4A have been mentioned in the interlocutory application at paragraph number 9 and at paragraph number 6 and 9 respectively. 3 का है 9 में और 4A का है 6. The learned counsel has also submitted that Wakalatnama on behalf of the proposed legal and heirs and successors has been filed along with the interlocutory application. The learned counsel for the respondents has opposed the prayer and has submitted that appellant number 4 with Makite died on 1/9/23 and there is delay. He has also submitted that the counsel was informed on 25/6/2024, but still the petition was not filed. So far as substitution of appellant number 3 is concerned, he has got no serious objection. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and the fact that the appeal has remained pending before this court since 1998, and initially respondent number 4 was substituted and thereafter 4A has also expired. Other legal heirs and successors of 4 are already on record. And it has been stated in paragraph 10 that the appellants are residents of remote village and consequently they later on could not contact the counsel for the appellant for quite some time. Considering the aforesaid facts and circumstances and being satisfied with the cause shown, the IN number 08.15 of 2025 is hereby allowed. The delay in filing the substitution to the extent of 521 days so far as appellant number 4A is concerned is also condoned, and the abatement is also set aside. The counsel for the appellant is directed to delete the name of the appellant number 4A and 3 from the cause title and insert the name of their legal heirs and successors in cause title during the course of the day. अब मेरे को best करिए सर, अब time of mine.
This is the judgment of reversal which is under challenge by the defendants, respondents, appellants. Now the substantial question of law which has been framed on 24/9/19.
एक sentence और लिखिए. With the consent of the learned counsel for the parties, the case is taken up on merits. Yes, please.
24/9/1998. The substantial questions of law have been framed. There are three substantial questions of law. Whether the registered sale deed dated 22/4/1954 would have been challenged by the plaintiff respondent by a suit instituted on 3/12/1988, that is after 35 years. Number B, whether in view of the judgment of this court reported in 1996 volume 1 BLJ page 94, the lower appellate court has misdirected itself in holding that the suit is not barred by limitation. C, whether the plaintiff respondent Bhakti Mia would have maintained a suit after 3 years from the date of attaining majority in view of the decision of the Honorable Supreme Court reported in 1994 volume 6 SCC 580. As a matter of fact,
dated 22/4/19, all are same primary.
yes, ma'am.
All the questions of law are
Practically, that is my
Practically the
submission.
same.
Practically, now, Your Lordship, the facts of the case which are not in dispute. The plaintiff found out a case in the plaintiff that on 22/4/1954, Exhibit 1, 22/4/1954 by Exhibit 1, the sale deed was executed in favor of the defendants. But their case is that purchase money was not paid to the executor of the sale deed. And secondly, they say that on 12/7/1954, Exhibit 2, the deed was cancelled.
12/7.
1954, within a period of less than 3 months, a registered deed of cancellation was executed, cancelling the sale deed.
Both are registered.
Both are registered. Now, thereafter, this suit was filed, on 3/12/1988. Now, the relief sought for in this suit,
3/12/19.
88. The relief sought for to the effect that it may declare that the plaintiffs have their subsisting right, title, interest, and possession over the suit. Declaration of right, title, interest, and possession. Number 2, declare that the sale deed dated 22/4/1954 is void, ineffective, and inoperative and not binding upon the plaintiff. These are the two reliefs. Normally, case of the defendants, as disclosed in the written statement, is that one fact note, another fact note which I should point out, para 11 of the plaintiff, para 11. At the time when the sale deed was executed by Mathur Mia, plaintiff number 1, Dipti Mia was a minor. Mathur Mia, however, had no right to sell the share of land of Dipti Mia, and the execution of the sale deed in favor of the defendants was itself a void document. This is the averment made in para 11. And para 12, that the plaintiff number 1, Dipti Mia, had no knowledge about the present deal as he was all along in service outside his village since he attended the host. But during the last Bhado, when he came to cultivate his lands in the suit clause, the defendants came armed with lathi, etc., and threatened the plaintiff with dire consequences. And thereafter, only on the last month, that the suit land was sold. Karamchari, local Karamchari rent receipt is being unauthorized issued to the defendants. So these are the three paragraphs practically. Now, so far the defendants are concerned, the appellant will see.
Para 11, 12 and 13.
Yes. Now, we the case of the defendants, not admittedly, a registered sale deed was executed by Mathur on 22/4/1954, and on the basis of registered sale deed, he obtained the certified copy, the original document, that is the case of the plaintiff also. He got his name mutated, and they have been paying rent to the government by coming in peaceful possession thereof, continuously right from the date of sale. This is the case of the defendant. Now, your Lordship may kindly come to the trial court judgment in order to appreciate the issues. Your Lordship may turn at page 17 of the trial court judgment. Page 17, in our page 17. Para 11. Sorry, in our page 17. Issue, sorry, in our page 14. Yes. In our page 11, sorry, I'm very sorry. In our page 11. Whether this suit is barred by law of limitation, issue number 6. Issue number 7 is this sale deed dated 22/4/1954 executed by Mathur Mia in favor of the defendants is void. So issue number 6 and 7 are the important issues. The other issues are with regard to valuation, subsisting right, title, interest, issue number 5. Then your Lordship may kindly see the discussion. So for documents I have already placed, exhibit 1, 2 and 3. 1 and 1/A are the rent receipt, 2 is the registered sale deed, exhibit 3 is the cancellation. Now, the discussion with regard to issue number page number 17. Page number 17.
Page is issue number 4.
Yes. Page number 17 with regard to limitation. Issue number 4. Issue number 4 is the faint blood, where I could find from para 10 onwards it has been discussed. Issue number 4, that is para 10, page 14, in our page 14.
It starts from para 9.
Para 9, issue number 4, yes, 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 though the defendants in their written statement para 5 have said that the value of that is valuation. Issue number 4 with regard to
Oh.
valuation.
Issue number 6,
6. That is not para 10 onwards.
paradigm, limitation.
Yes, ma'am.
Decided
That the
against you?
Suit is barred by law of limitation. It has been said that the defendants that the sale deed was executed on 22.
I have seen it. You just tell us
The
that what
concluding
is the-
portion, Your Lordship may kindly
It has been held to be barred by limitation.
barred by limitation. Then issue number 5 and 7.
5 and 7 is relatable to what? 7 is what? Void.
Why?
But that is not the issue before us.
Issue number
That
5
has
and
not been, that is not
substantial question.
not the substantial.
Not skipping it not. Then Your Lordship may kindly see issue number 7 has been answered by the learned trial court after discussion since para 11 onwards. The discussion of evidence and oral and documentary and ultimate finding Your Lordship will get at page number 39. In fact, Lord, page 38 was the last portion.
Yes.
Within 3 years of the when of his age of majority, then under Article 60 of the Indian Limitation Act, he cannot say about the illegality of the deed other than of long period. In my view, above discussion, I find and hold that the plaintiffs have got no right, title, interest, and possession over the suit land, and the sale deed executed in favor of by Muthur Miya in favor of the defendants cannot be declared to be null and void. This is not. These are the two issues not which have been written. Now, Your Lordship may kindly come to appellate court judgment. Appellate court judgment, Your Lordship may like to see para 18,
That
page
is the
5.
point number 1 and 2.
Points number 1 and 2.
That's right. So,
These are the
adverse
two-
possession we are not concerned. We
Whether
are only
the suit
concerned
is
by.
barred by law of limitation,
That's right.
whether the defendant have perfected their title by advance possession.
That's right.
That is not relevant. However, they are in possession on the basis of a registered sale deed. Now, Your Lordship may kindly see page 9, para 18. In fact, not para 17 onwards. May I be permitted to please?
Yes, yes.
I find that the defendants cannot base their title upon a void document. Regarding adverse possession, they have stated in para 15 of their written statement that the defendants are in continuous possession of the suit land without any late or hindrance from any quarter, including the plaintiffs for more than several 12 years, knowingly, and those defendants have perfected their right over the suit lands by law of adverse possession as well. The onus lies upon the defendants to prove that they have perfected their title by adverse possession. The rent receipts are not the document of title and possession. The tenant's ledger exhibit 2 is a worthless document. No mutation order has been filed. The continuous possession, the possession have been produced on behalf of both parties.
The witness on
Witnesses.
possession have been produced.
Witnesses on possession have been produced by both the parties. The plaintiffs have also produced some rent receipt, but the defendants cannot blow both hot and cold at the same time. They cannot base their title both on the basis of sale deed or by adverse possession at the same time. To prove title of the on the land suit land by adverse possession, it is not sufficient to show that some act of possession have been done. The possession required must be adjudged in continuity, in publicity, in the extent to show that it is adverse to real owner. Therefore, on a careful consideration of the evidence on record, I find that the defendants have not perfected their title by adverse possession. I also find that the suit not barred by law of limitation. No discussion. It has been held that it is not barred by law of limitation. These points therefore decided accordingly. Now wait, there are 2 points have been formulated. Now the next paragraph relates to point number 4, whether the plaintiffs have right title and subsistence. Although there is no point formulated there in the points for consideration. Now you will also may kindly see para 20. I find that the learned lower court, while deciding the question of limitation, did not discuss the effect of the execution of the sale deed by a de facto guardian of the plaintiff number 1 victimia. Therefore, the findings of the learned lower court on the point of limitation cannot be sustained. The learned lower court has observed that the defendants have not claimed that they are in possession by adverse. This observation is incorrect. The learned lower court has also wrongly placed reliance upon the rent receipts of the defendants, holding the sale deed dated 22/4/54 genuine and legal document. The learned lower court did not discuss whether the defendant's claim of adverse possession is maintained. Now, if I pause for a moment and I put a question to myself, this suit has to be, the plaintiff has to succeed on his own leg. The weakness of the defendant cannot be a ground to allow this decree receipt. This is the settled proposition of law. Now, my humble submission for Lordship toward the so far limitation point is concerned. Admittedly, there is no doubt or dispute with regard to the fact that they have challenged the sale deed of 1954 in the year 1988. Now, in this regard, there are 2 decisions which have been quoted in the substantial question of law. I may be permitted to place before Lordship. One is Lord, AR 1995 Supreme Court, page 75, para 5, which has been quoted, Lord.
1994 6 है ये.
Yes, 1994 6 SCC 585. That is equivalent to AR 1995 Supreme Court, page 72. This is the copy. Para 5 is Lord's independence.
1995 Supreme Court. Page number
75. That is 1994 volume 6 SCC 585.
para 5.
Yes, para 5.
Para 5 is
Very short judgment. Number the facts remains, the plaintiff did not plead and prove his age on the date of execution of the registered sale deed, and when he attained the age of majority. And as per para 11 and 12, 13, which I have read just now, your Lordship will recollect, he said that all throughout he is outside in a service. He was in service. So meaning thereby he was not minor at that time when he joined his service. The period is not mentioned. When he joined the service.
there is a finding that he was minor at that point of time, and there is no substantial question of law
Yes.
framed.
Your Lordship may kindly see there is a finding on the date of sale.
He was a minor.
He was minor. There is no dispute. Now my humble submission for Lordship, after attaining the age of majority, then the limitation starts running.
That's right.
That is my submission. So my Lord, it is to be filed within a period of limitation.
Within the period of 3 years.
3 years
From the date of attaining majority.
When, yes. When
Not
it-
from the date of knowledge.
not from the that
Judgment
is,
दीजिए.
that has been taken into consideration by the learned clerk.
जजमेंट दीजिए. अभी सुप्रीम कोर्ट का
तो वही
जजमेंट आया
दीजिए।
2025 में.
उसी para 5
2025 में जजमेंट आया है सर. अब आप देखे नहीं है तो इसका तो हम क्या ही करें. For minor, it has to be 3 years from the date of attaining majority,
Attaining-
irrespective of knowledge.
Yes.
वो कहाँ है? कौन सा सेक्शन है लिमिटेशन?
6, 7.
आपको मिला है, मिस्टर बैनर्जी?
So far as minority is concerned, Section 6 of the Limitation Act provides for that. Legal disability heading. It refers to a minor or insane.
When the disability ends, then it is 3 years.
3 years from that day.
Disability ends. And that is the
Disability-
consideration by the learned trial court.
That is the law. अभी नया जजमेंट आया, बहुत हार्डशिप का बात हुआ. He may not have knowledge. There are so many things taken into consideration. It will be 3 years from the date he attains majority, irrespective of the fact whether he has knowledge or he does not have knowledge.
Hence, it is also proposition of law that once registered sale deed cannot be cancelled by another deed of cancellation only after taking recourse to the provision of section 31.
So this is on so far as
Limitation.
Just a moment. This is on number 3, C. This judgment is on C. Section 8. Section 8 क्या है? What is section 8?
That is special exceptions. So far it is right of
Preemption
preemption.
होता.
That
That is
That
not
is
applicable.
and the
Article
corresponding schedule is in third divisions. That is from Article 118 onwards.
It is straight away covered by this section 6. So far as 3 years is concerned.
So this is the practically
What about the other one?
3. Other one on Patna High Court judgment has been
What is
referred.
it? Yes.
That is your 1996 volume 1 PLGR page 94
इसमें क्या है?
with limitation. Limitation prescribed there under Article 59 is 3 years for suit for cancellation of sale deed. If suit is filed after that period, liable to be dismissed as time bar. Cancellation of sale deed, suit for limitation.
This is
on
regarding cancellation of sale deed.
Yes.
This is
Therefore, the prayer was that declaration that the sale deed is null and void. And meaning thereby will not be in the garb of that, they want cancellation of the registered sale deed.
certainly because it
Of the
requires
unmarried.
evidence. The moment you pray for cancellation,
Yes. Then will not
it
the
has to be adjudicated.
now will not, they cannot place reliance upon cancellation deed of the year 1954 because this is against the in the teeth of not section 31 of the specific relief. Section
Specifically,
31,
in fact,
the remedy provided.
and even the court has not relied upon that.
We are upon this. Number 8, even 31 says any person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled. So the provision for cancellation is through suit under section 31 of the specific relief act. They cannot avoid this mandatory provisions. So circuitous way, the plaintiff sought for declaration and secondly cancellation of sale.
What about
And another judgment I beg to place reliance on Honorable Supreme Court, 18th May 2022. There are 6. There are 6 which starts from original plaintiff instituted this civil suit 2007 claiming cancellation of sale deed dated 19/4/1996 in respect of the suit property on the basis of decree obtained by civil suit number such and such. Now ultimate finding, this is the fact part. Then ultimately the next page will not. Therefore the suit which was filed by the original plaintiff for cancellation of sale deed can be said to be a substantive. Therefore, the same was clearly barred by limitation. Hence, the learned trial court ought to have dismissed this suit on the ground that the suit was barred by limitation. As such, the learned first appellate court was justified and right in setting aside the judgment and decree passed by the learned trial court, and consequently dismissing the suit. The High Court has committed a grave error in quashing and setting aside the well-reasoned and detailed judgment order passed by the first appellate court, dismissing the suit and consequently restoring the judgment and decree passed by the trial. So here in my case, otherwise, it is original court dismissed the suit, appellate court set aside the order, judgment of the trial court, and restored the suit and decreed the suit. So these are the points which I will to ask.
Yes, what do you have to say?
Yes. Let me just first refer to the reliefs which were sought for in the plaintiff. This title suit 133 of 1988. Paragraph.
Yes, paragraph 1.
Paragraph 18, the relief which has been sought for.
Yes.
That upon adjudication it to be declared.
You are referring to the plaint.
Plaintiff.
Record it.
These are correct.
It is mentioned in the improved judgment also. The suit for declaration of the title and possession over the land.
The language is plaintiffs have their subsisting right, title, interest, and possession over the suit land.
And further relief.
And then it is the word says subsisting right, title, interest, and possession. First relief. And second is that the sale deed dated 22/4/54 is quite void, ineffective, and inoperative, and not binding upon the plaintiffs. So these are the reliefs sought for. The language is first one is subsisting right, title, and second is that is quite void, ineffective, and inoperative.
You are challenging the sale deed, clear cut.
But it is, so far as the sale deed is concerned, we are saying that declaration that it is void. And now the reason for seeking this relief is 22/4/54 sale deed was made. It was cancelled immediately thereafter.
No,
So
what
such
is the process of cancellation? Mr.
cancellation-
Sani, you have not placed this judgment 1996 volume 1 BLDR. ये
Yes.
भाई substantial question of law में लिखा है तो देना
दिए
पड़ेगा।
दे दिए कॉपी दिए
कौन सा?
दिए यस तुरंत दिए
नहीं, ये तो अभी recent judgment है।
कौन
बस
सा?
2022 का।
नहीं, सर जी दे दिए
ये भी limitation पर है क्या?
Sir, do not limitation. Suit after 3 years, it is barred by limitation. In fact, all the 3 questions related to limitation, although separately formulated, but sum and substance is the same.
हाँ ठीक है, बताइए।
Yes. Now the basis of the suit was that first thing that it was without consideration. The said sale deed was without consideration. And then the second thing was that one of the executor of the sale deed, that is the plaintiff number 1. Plaintiff number 1 was a minor at that point of time when the sale deed was executed. And the plaintiff number 2 was not the duly appointed guardian. And so far as under the Muslim personal law,
Why are you coming with Muslim personal?
because we are intending to submit that the said execution of the sale deed was itself not permissible. The said sale deed is therefore void ab initio, and even otherwise, therefore, we have sought for a declaration that it is void. That it is void. And
Was this your case that under the Muslim personal law it cannot be done?
yes,
Did you make out this case?
yes, yes,
Which paragraph?
we have referred in the plaint itself after giving the description. And para 7-8 is about the consideration money. Paragraph 11 onwards of the plaint.
That under the Muslim law this is not permissible.
Yes.
Which paragraph is that?
Paragraph 11. Plaint. We have said that at the time when the sale deed was executed by Mathur Miah, plaintiff number 1, Vikti Miah was a minor. Mathur Miah, however, has had no right to sell the share of land of
It's
Vikti
a
Miah.
general statement.
General. Therefore, now this statement finds supports from their personal law that he was not appointed a guardian. He was not appointed a guardian, and therefore he could not have executed the sale deed on his behalf, or the minor could not have executed the sale deed. And in this regard, there is categorical discussion in the judgment. So our contention was that this sale deed was itself void ab initio, and so in respect of a void document, there is no need of any cancellation, and therefore we
You
have
have prayed for cancellation.
we have prayed for a declaration that it is a void document. We have not specifically used the word cancellation. Therefore, we have chosen the words for declaration that it is
One
quite
and the same.
void.
You have specifically challenged the same.
Now, that has a relevancy. That has a relevancy because so far as the limitation part is concerned, when a void document is there, then the authority was itself not there. Plaintiff number 2, being the elder brother, he was not the guardian in accordance with law to execute the said sale deed on his behalf.
Under the provision of Muslim law, what is the method of appointing a guardian?
359 explains.
Okay, anyways, your main point was that it is void and therefore it is void ab initio, so limitation has got no application.
In such a case, there is no occasion for applying the principles of limitation in such a case, because had it been a voidable instrument, then limitation would have come.
So for Muslim law, section 6 is not applicable.
So far as section 6 is concerned, that is applicable in case of it would be applicable in case of any such voidable instrument or such instrument
Let's
which
read
is
section
illegal.
6,
Yes.
which says that it is only applicable in case of voidable
Because
instrument.
the language is concerned, we have to understand it in this manner. Legal disability. It is about a person challenging a sale deed after attaining majority. Where legal disability, the language is like this: where a person entitled to institute a suit or make an application for the execution of degree is, at the time from which the prescribed period is to be reckoned, a minor or insane or an idiot, he may institute the suit or make the application within the same period after disability has ceased, as would otherwise have been allowed from the time specified in the third column of the schedule. So this is in respect of such instruments which is not void ab initio, because void ab initio is a document which is non-existent in the eye of law. So provisions of section 6 cannot be applicable in case of such a non-existent document which is nonest in the eye of law.
The document was executed on behalf of both the brothers.
Yes, both the brothers. We have brought on record the original cell deed, and it was our further case.
So you want to say that did you challenge it only to the extent it related to your share, or both the brothers challenged?
Both the brothers challenged.
What is the ground of challenge so far as the elder brother is concerned?
Is concerned that the consideration amount was not paid, and there is concurrent.
Then his case was maintainable.
And then it was also recorded that the finding recorded of fact by both the courts that consideration amount was not paid.
That is another thing. But the point is whether when the consideration amount is not paid, then under such circumstances the limitation will not apply.
The brother has been impleaded because
both the brothers
yes,
they joined together
because
to
both,
challenge a deed in which one is competent and other is not competent.
Yes. Therefore, both the brothers have been joined as plaintiffs since both of them have executed the cell deed. Therefore, they have been joined as plaintiffs, and that is the reason for joining them both as plaintiffs. That is the reason for joining them as plaintiffs. And so far as the findings of the learned first appellate court, may I just place it? After formulation of the points for determination, the 4 points as this honorable court has found, and just after there, paragraph 7 onwards, the findings. The first is with regard to whether the cell deed dated 22/4/54 exhibit 4 is illegal and void, and it is also and it would be also relevant to mention that we have brought on record the original cell deed of the year 1954. Though the cancellation of a registered cell deed can only be done in the manner provided under section 31. But the cancellation here supports our case so far as its execution without consideration amount is concerned. And it is further supported from the fact that
But execution by itself is not in this.
but the original cell deed was in our custody.
Whosoever custody
Because possessing the original cell deed, that has a relevance.
That is not the scope
That
of
because
our,
until unless the original cell deed.
that is not the scope of our discussion.
Here we have to see the entire attending circumstances so far as the question of law are concerned. Because the original cell deed, we produced it. The original cell deed, which otherwise ought to have been in possession of the other side,
You got it cancelled.
cancelled. And so the original cell deed was never handed over to them since the consideration
So
amount was
if
not
the
paid.
deed is cancelled, you will deposit it in the registry office, or you will retain both the deeds.
It was taken back by us, original cell deed. It was taken back by us because registration office only maintains the record, and therefore it has been held in certain cases the issue of public
See.
document, that it is not a public document in terms of section 74 of the Evidence Act. May I read out findings, paragraph 7 of the learned appellate court on the point number 2. That is internal page 4 of the.
You read para 5 onwards. Para 5 also.
Yes. The case of the defendants, on the other hand, is that the plaintiff number 2, Mathur Mia, executed the cell deed on 22/4/54 after receiving the entire consideration from Wahid Ali Mia and Babul Mia. The subsequent cancellation deed made in the registry office has no legal sanctity, nor the cell deed executed by Mathur Mia on 22/4/54 has been cancelled by any competent civil court. The plaintiff, however, kept the chirkut with himself due to malice intention, and in spite of several demands by Wahid Ali Mia and Babul Mia and the defendants for the chirkut, Babul Mia on one pretext or other did not give the chirkut, and thereafter the defendant obtained the certified copy of the cell deed from registry office. The state of Bihar accepted the defendants as their tenants, and on the basis of mutation order, the defendants are obtaining the rent receipts and are coming in continuous possession over the suitcase without any letter of interest from any quarter for more than several years, and have perfected their title by law of advance possession as well. It is contended that Mathur Mia had executed the cell deed for himself and being the natural guardian of the minor Dikti Mia, and after a lapse of 35 years from the date of execution of the cell deed, the statement of the plaintiff is of no value. Dipti was aged about 15 years when the sale deed was executed on 22/4/54 and attained majority in their 57 and was living in his village home all through and he had full knowledge about the transaction. It is further contended that the plaintiff have no cause of action for the suit. The suit is barred by law of limitation, estoppel, negotiation. Then the 4 points have been formulated. First one is with
You
regard
read point number 2.
yes. It is admitted in case of the parties that the plaintiff number 2, Mathur Mia for himself and also for his minor brother plaintiff number 1, Dipti Mia executed registered sale deed dated 20th April 54, that is exhibit 2 in favor of father of the defendant number 1 to 3 and the defendant number 4. It has been provided under section 359 of the Mullah's Principles of Mohammedan Law, who are entitled to be legal guardian of the property of a minor. The father, the executor appointed by the father's will, the father, then the executor appointed by the father's will, then the father's father, and the executor appointed by the will of the father's father are entitled to be the guardian of the property of a minor. Four persons have been approved. It has been specifically mentioned in section clause 361 of the above Mohammedan law that a person may neither be a legal guardian nor a guardian appointed by the court, but may have voluntarily placed himself in charge of the person and property of a minor. Such a person is called de facto guardian. A de facto guardian is merely a custodian of the person and the property of the minor. Further, under under clause 362, it has been mentioned that a legal guardian of the property of a minor has no power to sell the immovable property of the minor, except in the cases mentioned there. Therefore, from the modern law, it is well established that neither the mother nor the brother is a legal guardian of the property of a minor. They may be a de facto guardian, but under clause 364 of the above Mohammedan law, de facto guardian has no power to transfer any right or interest in the immovable property of the minor. Such a transfer is not merely voidable, but void. The sale deed dated 22/4/54 is therefore void because of the fact that Mathur Mia, the brother and the de facto guardian of the plaintiff number 1, Dipti Mia, had no power to transfer the immovable property of the minor brother Dipti Mia. This point is decided in favor of the appellants. Then, paragraph 9. Whether the suit is this point number 1 and 3 have been discussed.
You read it please, para 9.
Yes.
सारा कहानी लिमिटेशन में उसको omit मत कर.
नहीं वही पैरा 9 ही बोल रहे हैं.
पढ़िए.
2 points are there, whether the suit is barred by law of limitation and other is with regard to adverse clause. These points are interconnected, therefore they are being taken together. The learned counsel for the respondents has contended that the suit is barred by limitation. Article 91 of the Limitation Act has provided a period of 3 years to cancel or set aside an instrument from the date when the facts entitling the plaintiff to have instrument first become known to him. In this case, I find that this article will not apply, where the instrument, the sale deed dated 22/4/90 is itself null and void. Such a document need not be cancelled or set aside by a suit brought within 3 years under this article. But the plaintiff can bring a suit for declaration, possession or other reliefs without praying for cancellation of the document. The plaintiff have filed this suit for declaration of their title and possession. They have claimed possession over the suit land based on the title. Therefore, Article 144 of the Law of Limitation Act shall apply. This corresponds to Article 65 of the 1963 Act. One thing, however, is clear that this is not a suit for recovery of possession. This article does not apply unless the plaintiff is out of possession. However, the defendants can show that the plaintiffs are out of possession for more than 12 years, and in that case, they have acquired title by adverse possession. The case of the defendants that they are in possession since the date of execution of the sale deed, Therefore, they have remained in possession for several 12 years and have perfected their title by adverse possession. I find that in case of adverse possession, the person claiming to be the real owner should have stood by, while others continued to possess, not by any derivative title, but in practical contravention of his alleged right. In the present suit, the defendants can have claimed their title by adverse possession only if they had not claimed their title on the basis of sale deed. Since the defendants have claimed their own title over the suit lands on the basis of sale deed dated 22/4/54, they cannot have declared their hostile title to the real owner. Their title might have perfected by adverse possession in case they had accepted that the plaintiffs are the real owners. And while the defendants continue to possess the suit lands, the real owner, that is the plaintiffs, had stood by and allowed them to continue in possession without any hindrance. The plaintiffs have alleged that on the presentation of the sale deed for registration before the sub-registrar, the defendants assured that he or they would pay the consideration money at his village home. Despite several attempts made by the plaintiff, Mathur Mia, the defendant did not pay the consideration money. They also did not bring out the original sale deed from the registration of his Hadariwal. PW4, the plaintiff number 2, has stated that the checkbook remained with him and due to non-payment of consideration money, he obtained the original sale deed from the registration office. Exhibit 3 is the registered cancellation deed dated 12/6/54 executed by the plaintiff which they have cancelled the registered sale deed dated so and so. From Exhibit 2, it appears that the registering authority has endorsed the cancellation over the original sale deed dated 22/4/54. From these transactions by the plaintiffs, it appears that the registered sale deed was cancelled by a registered document after about 120 days of execution. The question whether title to property under a sale deed passes upon its execution and registration or is postponed until the payment of the entire consideration depends on the intention of the parties, which must be gathered from the sale deed itself. Where neither the sale deed nor possession of the property sold is delivered to the vendee and no consideration passes, the mere registration of the deed does not operate to pass title to the vendee. From the surrounding circumstances, that is the registration of the sale deed and its subsequent cancellation within 2 months and custody of the original sale deed, a good case is made out in favor of the plaintiffs that the full consideration money had not passed. The plaintiffs have adduced evidence to show that despite the execution of the sale deed, they continue to remain in possession over the suit lands. PW1 and PW6, Dwadikaram and Bhagwat Sharma are formal witnesses. They have proved 2 rent receipts marked Exhibit 1 and 1/8. PW2, Babli Ansari has stated that the plaintiffs are in possession over the suit lands. He is a cousin of the plaintiffs. PW3, Bhutan Mia has also stated that plaintiffs are in possession over the suit lands. He has never seen the defendants cultivating the land. PW4, the plaintiff number 2 has also stated about his possession. PW5, Kalutini is also a witness of the possession of the plaintiff over the suit lands. On the other hand, the defendants have produced 5 witnesses, including the defendant number 4, Babul Mia. DW1, Ganpadra has proved 9 rent receipts marked Exhibit A series. DW2, Badhan
How
Mir.
the court is coming to a conclusion at para number 18 that suit is not barred by limitation.
So far as
Where is the discussion so far as point of limitation is concerned?
here, just on point number 2,
Adverse possession is declined.
adverse decline, and point number 2 itself. Point number 2, paragraph 7. Paragraph 7. Paragraph 7 and 8, where it has been recorded that the sale deed is therefore void.
There is a finding that the sale deed is void.
Yes, there is a finding that it is void, and then after that, 7 and 8, after 7 and 8, then in continuation 9. So far as in continuation 9 is there, where Article 91 of the Limitation has been considered. And there, Article 91 of the Limitation Act has provided a period of 3 years to cancel or set aside an instrument from the date when the facts entitling the plaintiff to have the instrument cancelled first become known to him. In this case, I find that this article will not apply, where the instrument, the sale deed dated 22/4/90 is itself null and void. Such document need not be cancelled or set aside by a suit brought within 3 years, but the plaintiff can bring a suit for declaration, possession or other relief without praying for cancellation of the document. And then further, in after para 9, para 10, the plaintiffs have filed this suit for declaration of their title and possession. They have claimed possession over the suit lands on title. Therefore, Article
So
140.
your case is that so far as the point of limitation is concerned, your straight case is that it is null and void, and therefore limitation would not run.
Because law does not provides for cancellation of a void document. And in this regard, may I place reliance upon the judgment of the Honorable Supreme Court?
So void document need not be cancelled.
Need not be cancelled. 2006 Volume 5 SCC, that is paragraph.
Was there any dispute in connection with the age?
No, there is no dispute regarding that. Minority at the time of execution, that is admitted by themselves, because they say we plaintiff number 1 attained majority after 3 years of that. He was 15 at that point of time, so that is not disputed. And this in the judgment of Prem Singh versus Birbal, it has been categorically said that whenever a document is valid, no question arises of its cancellation. When a document is void ab initio, like in the present case, a decree for setting aside the same would not be necessary, as the same is nullest in the eye of law, as it would be a nullity.
But once you seek a decree, you are seeking a decree.
We are seeking not for the decree, we have sought for subsisting right title interest.
You are seeking a decree that this document, this sale deed is void ab initio. It is one thing to say that it was there in the body of the claim, that it is not binding on you. But once you seek a relief that it is void ab initio, or it is void, then limitation has to be seen.
But there is a distinction. We have not prayed for cancellation.
It's one and the same thing.
We are praying only for declaration that it is void. Only for
You don't need a declaration at all for a void document.
void, because
No suit is required to be filed. No prayer is made.
for
required to
cancellation
be made.
no suit is required. We are not praying for cancellation. There is no word of cancellation in the relief sought for. That may be significant for the purpose of adjudication of the issues, because we have not used the word cancellation. We have simply, the first relief, primary relief, is about declaration that there is subsisting right title interest possession. Therefore, subsisting words are there. And the second relief is that declaration that it is void. And therefore, a finding has been recorded that it is void. We are not seeking for cancellation.
There is no doubt that that a registered deed has to be cancelled by a process of court.
That we cannot.
There is no doubt.
That. Therefore, we are not stressing on that cancellation. Keeping apart that cancellation, without considering that cancellation, it is apparent in view of the admitted facts that he was minor, and the sale deed was executed by him and not by a duly appointed guardian in terms with the law they were governed, the personal law they were governed. And so far as contract with a minor is concerned, which is not permissible in law,
So the entire deed will be cancelled because one of the vendor is a minor,
yes.
or only to that extent it will be cancelled.
So far as we have not sought cancellation. We have said that
No, what is the entire document will become void if one of the vendor is a minor.
because the contract is in totality. One minor is there, who was not competent to enter into a contract. So it is it has to be considered in totality, because he was in party, and so there was no consensus ad item.
Consensus ad idem with the minor. What about the major?
Because it was presented in such a manner that both of them had consensus ad item with the other side, with the purchaser. But since the minor was not competent to enter into agreement, so the whole agreement becomes void.
Where is the deed?
It is Exhibit 1.
The payment of consideration has been shown in Exhibit 1. That
Just-
has been considered by transfer. Received the payment.
Exhibit 1.
Exhibit 1.
इसमें कहाँ लिखा है that he is executing the sale deed on behalf of the minor also? Mithun Mia.
Arjun Mia.
Where is it mentioned that he is executing the
Sarju Mia. And
Mathur Mia?
हाँ,
आगे?
and उसके बाद बिप्ती मिया, सेकंड लाइन, खुद.
बिप्ती मिया है ना माइनर का नाम?
हाँ, उसके बाद नेक्स्ट लाइन में खुद व वाली बिरादर हकीकी.
बिप्ती मिया तो कहीं लिखा है?
हाँ, सेकंड लाइन में है. उसके जस्ट नाबालिग करके देखिए, सेकंड लाइन में
अच्छा,
लास्ट.
बिप्ती मिया,
हाँ.
नाबालिग.
हाँ, वह खुद व नाली बिरादर हकीकी बिप्ती मिया पेसरन नाबालिग सरजू.
और एग्जीक्यूशन में दोनों का सिग्नेचर है? ऑन बिहाफ है कि दोनों का सिग्नेचर?
खाली इसी तरह
Mathur Mia is the plaintiff number 2. He has executed the sale.
माथुर मिया का ही खाली, बिकॉज वो वहाँ
Mathur Mia also
रिप्रेजेंटेशन
challenging
रिप्रेजेंटेशन का रेफरेंस है. Yes, put it.
आपको कुछ बोलना है?
The judgment which has been cited by my friend is a Prem Singh. So let us just see, it is not paragraph wise, but the last but one page. Last but if a deed, as you know, see, last but one page.
Yes.
The last paragraph.
Hmm.
If a deed was executed by the plaintiff when he was a minor and it was void, he had two options to file a suit to get the property purportedly conveyed thereunder. He could either file the suit within 12 years of the deed or within 3 years of attaining majority. Here, the plaintiff did not either sue within 12 years of the deed or within 3 years of attaining majority. Therefore, the suit was rightly held to be barred by limitation by the trial. What my learned friend is relying upon. After discussion of Article 91, and secondly, you will also kindly see, there are two plaintiffs. One of the plaintiff is the executor of the deed for himself and on behalf of the plaintiff number one. Now he received the consideration money that is incorporated in the deed itself. And now he turned around and after so many years, 35 years, he joined with the Diptimia on the ground that Diptimia was mine. And he is alleging against himself. And that too after 35 years.
That's all.
On the, so far as 94.6 SCC, which is referred in the order framing substantial question of law, there this issue was not there so far as the nature of a document is concerned. And so that judgment, the factual matrix of that judgment is different, which is here in our case. There is a finding recorded by the learned first appellate court that the deed is void, and so that judgment may not be applicable in our case. So for that, and on the issue of minor entering into contract, one judgment of the Honorable Apex Court.
Minor did not enter into the contract. How this is applicable?
Para 7.
He is not a party to the deed, as per your own case. Diptimia was not a party to the deed. I can understand that minor entered and he executed registered sale.
Paragraph 7.
This is not the case here. Thurmia is the major.
Because the deed made in the name of the minor, the plaintiff number 1, showing him a party to the deed. And there is no ratification of the deed by the minor at any point of time.
Immediately after cessation of the inability, the right accrued. On this judgment, Prem Singh discussed everything.
For the learned counsels appearing on behalf of the parties, this appeal has been filed against judgment passed in title appeal number 56 of 1990 / 27 of 1992, reversing the judgment and decree, reversing the judgment dated 28/6/1990 within bracket decree signed on 18/7/1990, passed by the Municipal BDT title suit number 133 of 1988. The appellate court judgment was passed by First Additional District Judge DT. This appeal was admitted for final hearing by the order dated 24/9/1998 on the following 3 substantial questions of law. The learned counsel for the appellant has submitted that essentially all the 3 substantial questions of law are relating to the point of limitation. while referring to the impugned judgment, while referring to the trial court judgment, the learned counsel has submitted that the suit was held to be barred by limitation. And so far as the learned first appellate court is concerned, it was held that the suit was not barred by limitation as the sale deed itself was void ab initio. Itself was null and void. Null and void, na?
हाँ इसमें findings है illegal and void. Language. Void ही word use.
Khali void
खाली void.
was void. The learned counsel submits that was void and illegal document. यही है finding. The learned counsel submits that both the plaintiffs, one major and another minor, at the relevant point of time, had executed the sale deed dated. The learned counsel submits that the plaintiff number 2 was the learned counsel submits that both the plaintiffs are full brothers and plaintiff number 1 was minor as on (22/4/1954). But so far as plaintiff number 2 is concerned, he was major. Plaintiff number 2 had executed the sale deed with respect to the property in which the name of plaintiff number 1 also figured,
On behalf of
and the deed was executed by plaintiff number 2 on behalf of himself and also on behalf of the plaintiff number 1. The learned counsel has further submitted that the suit was filed in the year 1988,
3/12/1988.
3/12/1988, and by that time 34 years had already elapsed. He has also submitted that as per the records, the plaintiff number 1 was 15 years of age
On the date of execution of the
on
suit.
22/4/1954, and thereafter he attained majority. But in spite of attaining majority
In 1957.
in the year 1957, no steps was taken to get the sale deed declared void or for cancellation of the sale deed. He has also submitted that the plaintiffs not only prayed for cancellation of sale deed on the ground that plaintiff number 1 was minor, but also on the ground that no consideration amount was paid in connection with the sale deed. He submits that the sale deed itself indicated payment of consideration amount. However, considering the substantial question of law, the learned counsel submits that once the suit is barred by limitation, there is no question of entering into the merits of the matter. He has then referred to the relief as prayed for in the plaint and has submitted that a declaration was sought that the sale deed dated 22/4/1954 is quite void, ineffective and inoperative and not binding upon the plaintiffs. He submits that once the deed is challenged, the provision of Limitation Act comes into play. And even for a declaration of deed as void, evidence is required. The learned counsel has further submitted that so far as the judgment referred to in the substantial question of law is concerned, which is reported in bracket 1994 bracket row 6 SCC 585, Darshan Singh and others versus Gurdev Singh. He has referred to paragraph 5 thereof. To submit that the provision of section 6 of the Limitation Act has been considered and the suit has to be filed within 3 years from the date of cessation of disability. He submits that once plaintiff number 1 attained the age of majority, the disability ceased and therefore the suit was required to be filed within a period of 3 years upon it attaining majority, failing which the suit itself was barred by limitation. The learned counsel has also placed the judgment passed by Honorable Patna High Court as referred to in the substantial question of law, and he submits that what's the paragraph, sir? And has referred to
Last position.
and has referred to paragraph 16 thereof to submit that once a registered sale deed was obtained, and has submitted that once a registered sale deed was, it has been held that once a registered sale deed was obtained for adequate consideration and if someone feels aggrieved, he has to file a suit for cancellation of the same within a period of 3 years as contemplated under Article 51 of the Limitation Act. And if that is not so done, then the suit becomes barred by limitation. The learned counsel has also submitted that some steps were taken for by the plaintiffs. कब लिया था step?
After 2 months, that is
By-
12/6/1954.
By plaintiff number 2.
12.
By plaintiff number 2.
Yes,
By plaintiff number 2 on 12/7/1954
54.
for cancellation of the deed, sale deed, but the same was of no consequence. He has referred to section 31 of the Specific Relief Act to submit that the registered deed for cancellation,
It speaks about void and voidable, section 31.
it speaks about void and voidable sale deed, and by virtue of the same, a suit is required to be filed for a declaration of sale deed as void or voidable. The Learned Counsel has submitted that the Learned First Appellate Court has erred in law while dealing with the point of limitation, and therefore the substantial question of law be answered in favour of the appellant and against the respondents. The Learned Counsel for the respondents has submitted that in a case where the sale deed is void ab initio / nullity in the eyes of law, there is no need to challenge the sale deed, and accordingly no prayer was made in the suit for seeking to set aside the sale deed dated 22/4/1954. The Learned Counsel has also submitted that the parties are governed by Mohammedan law and the plaintiffs are governed by Mohammedan law, and plaintiff number 1, the plaintiff number 2 had no locus to execute the deed on behalf of plaintiff number 1, and therefore the deed so executed was ex facie null and void and nullity. In such circumstances, the point of limitation will not come into picture. The Learned Counsel has also referred to the judgment passed by Honorable Supreme Court in the case of Prem Singh and others versus Birbal and others, reported in bracket 2006 bracket close 5 SCC 353, and has referred to paragraph 16 thereof to submit that when a document is valid, there is no question of its cancellation, but when a document is void ab initio, a decree for setting aside the same would not be necessary, as the same is non-est in the eyes of law, as it would be a nullity. However, during the course of argument, it is not in dispute that as per section 31 of the Specific Relief Act, once a deed is registered, its cancellation has to be through a civil suit. And another deed of cancellation of a registered deed is not permissible in the eyes of law. Correct. In response, the Learned Counsel for the appellant has referred to paragraph 28 of the judgment passed in the case of Prem Singh, and has submitted that in the said case, the deed was executed by a minor, and it was observed that if a deed is executed by a minor, it is void, and he has two options: either to file a suit to get the property conveyed thereunder, or he could either file a suit within 12 years of the deed or within 3 years of attaining majority. And if no such step is taken, the suit will be barred by limitation. After hearing the Learned Counsels appearing on behalf of the parties, this court finds that Vipat Mia and Mathur Mia had filed the suit for the following relief. One, upon adjudication, it may be declared that the plaintiffs have their subsisting right, title, interest, and possession over the suit land. Roman 2, that it may further be declared that the sale deed dated 22/4/1954 is quite void, ineffective, and inoperative, and is not binding upon the plaintiffs. Roman 3, that the cost of the suit be awarded to the plaintiffs. Roman 4, any other relief as payment paid. It is not in dispute that the suit property was covered. Entire suit property is covered.
जी हाँ
Entire suit property was covered by the sale deed dated 22/4/1954. This court finds that the perusal of the plaint revealed that the relief as prayed for in the plaint reveals that the plaintiffs sought a declaration that the sale deed dated 22/4/1954 was void. And thus, there is a specific challenge to the sale deed. The suit was contested on various points, including the point of limitation, which is the bone of contention, considering the substantial questions of law. A specific plea was raised that the suit was not maintainable after having fined 35 years from the date of its execution. It was also asserted that Mia attained majority sometimes in the year 1957, and in spite of that, he did not take any steps to challenge the sale deed. The fact remains that the plaintiff number 2, who had executed the sale deed on behalf of himself and on behalf of the plaintiff number 1, was undisputedly major at the time of execution of the sale deed. This court finds that the learned trial court had framed various issues, including the point of limitation, and also as to whether the deed was void. Those issues were issue number 6 and 7. By deciding issue number 6, the learned trial court held that the suit was barred by limitation. The finding is in paragraph 10. And by deciding issue number 7, which was decided along with issue number 4, the learned trial court held that the legality of the deed could not be challenged after long period, and also held that the plaintiffs had no right, title and possession over the suit land, and the sale deed executed by plaintiff number 2 in favor of defendants cannot be declared null and void. The learned court also declared that the plaintiffs had no cause of action and were not entitled to any relief. So far as the learned first appellate court is concerned, the point of limitation has been dealt with in paragraph 9. And the learned first appellate court was of the view that the Article 91, that when the instrument is null and void, the point of limitation would not apply, and such a document need not be cancelled or set aside by bringing a suit within 3 years. And also observe that the suit was brought within a period of 3 years, and the suit was brought without praying for cancellation of the document. The learned court in paragraph 10 observed that the plaintiff had filed the suit for declaration of the title and possession. And the suit was not for recovery of possession. However, the learned court refused to grant the plea of adverse possession as claimed by the plaintiffs. The learned court thereafter entered into the merits of the matter and was of the view that full consideration amount did not pass in connection with the settlement. The learned court also recorded that the defendant cannot base their title upon a void document and ultimately held that the suit was not barred by limitation. The learned court also considered that plaintiff number 2 would be de facto guardian of plaintiff number 1, but could not have executed the same. Ultimately, the learned first appellate court held that the sale deed dated 22/4/1954 is a void and illegal document. however rejected the plea of adverse possession by the appellants, by the plaintiff. This court is of the consideration so far as the substantial question of law number A is concerned. The same assumes importance in view of the fact that the plaintiff number 2 was major at the time of execution of the sale deed, and admittedly the sale deed was challenged after expiry of 35 years from its execution. The substantial question of law number A has to be seen with the substantial question of law number C, wherein the plaintiff number 1 was minor at the time of execution of sale deed dated 22/4/1954, and his property was sold by plaintiff number 2 for himself and on behalf of plaintiff number 1. But admittedly the plaintiff number 1 did not maintain a suit to get back the property even after attaining majority within 3 years from the date of such majority. This court is of the view that in the judgment passed by Honorable Supreme Court reported in bracket 1994 bracket close 6 SCC 585, in paragraph 5 it has been clearly held that the period of limitation to challenge the sale deed is 3 years from the date that disability ceases. In the present case, disability ceased with respect to plaintiff number 1 upon attaining majority, but in spite of attaining majority, he did not challenge the sale deed. Consequently, when seen in the light of Section 6 of the Limitation Act, there is no dispute that challenge to the sale deed on the ground that the plaintiff number 1 was minor at the relevant point of time in the year 1954 when the sale deed was executed, the suit was barred by limitation, as the suit was filed after the expiry of 30 years from the execution of the sale deed. This court also finds that in the judgment passed by Honorable Supreme Court reported in bracket 2006 bracket close 5 SCC 353, in paragraph 28, the Honorable Supreme Court has clearly held that if a deed was executed by the plaintiff when he was a minor and it was void, he had two options: either to file a suit to get the property reconveyed within 12 years of the execution of the deed or within 3 years of attaining majority. In the present case, the plaintiff number 1 did not take the necessary steps within the prescribed period of limitation, although his property was transferred by the deed of the year 1954. In paragraph 17 of the judgment passed in the case of Prem Singh, it has been observed that once a suit is filed by the plaintiff for cancellation of a transaction, it would be governed by Article 59. Even if Article 59 is not attracted, the restitutory article would be attracted. In the present case, the plaintiffs had filed the suit for declaration that the sale deed was void. The same necessarily amounts to challenging the sale deed. And in order to get declaration of sale deed as void, it requires adjudication. It is one thing to say that the sale deed was void ab initio and need not be challenged, and it was not actually challenged in the suit. And it is another thing to say that the sale deed was sought to be declared void, and having declared void, it is void ab initio and nullity, and the point of limitation would not apply at all. In the present case, the point of limitation would certainly apply, and therefore the learned first appellate court was not justified in holding that the plea of limitation would not apply. Considering the aforesaid facts and circumstances, the substantial question of law A and C are answered in favor of the appellant. ये B में क्या करें? ये भी तो वही है, हाँ?
ABC तीनों एक ही है,
तीनों एक ही
है लेकिन पार्ट कर दो।
1996. So far as substantial question of law number B is concerned, the learned appellate court has certainly misdirected itself in holding that the suit was not barred by limitation. Once the deed is registered, sale deed is registered, the only remedy to set it aside is through the process of court in view of section 31 of the Specific Relief Act. And the action taken by the plaintiffs to execute a cancellation deed by itself has no sanctity in life. Consequently, the second substantial question of law is also answered in favor of the appellant. This court is of the view that once the suit is barred by limitation, adjudication on merits has got no relevance at all. In view of the aforesaid facts and circumstances, the judgment passed by the learned first appellate court is hereby set aside. That's all.
एक मेरे सबमिशन में एक जजमेंट जो रिलाई किए थे कृष्णा बेरी वो कॉपी दिए थे वो खाली नहीं आया
कौन सा?
कृष्णा बेरी वन माइनॉरिटी पैरा 7 2024 एससीसी ऑनलाइन
2024. हाँ,
पैरा 7
एक सेकंड. The learned counsel for the respondents has relied upon the judgment passed by the Honorable Supreme Court, Report 18/2024, SCC Online SC 1903, Para 7, which is quoted as under. This court is of the view that the same judgment does not apply to the facts and circumstances of the case, as the issues, the substantial question of law herein are related to point of limitation, and this court has held that if the deed is sought to be declared as void, the same has to be challenged within the period of limitation as prescribed under the limitation.
The trial court judgment should be restored after setting
Appellate court judgment
is set aside.
is set aside. The suit stands dismissed.
dismissed up to his deed stands the registered sale deed
Online.
public
allowed. For Passover, Mr. Singh.
Password case item 12, second April 69 of 2021.
You are harping upon which substantial question of law as framed?
No, it is under.
You have framed altogether 7 substantial question of law. Which is the substantial question of law you are relying upon?
Second, whether the learned trial court and learned lower appellate court totally failed to consider the plaintiff's witnesses and defendant's witnesses, although the plaintiff had given 7 witnesses and defendant had given 5 witnesses, which make the judgment of the 2 courts below bad and illegal for total non-consideration of the oral evidence of the parties.
The first appellate court has reversed the judgment or upheld it?
That it is in concurrence.
Concurrence.
It's an affirmance.
There is a discussion of the evidence of your plaintiff's witness
My lord,
in the trial court.
the issue starts from page 25 of the memo. There is plaintiff witness has now been discussed. Actually, what has happened?
Trial court has also not discussed.
There is no reference कि किसने क्या बोला, किसने क्या किया. Certain exhibits of the defendants have been taken into consideration. Page 31 onwards.
इसका रिकॉर्ड आया हुआ है. कभी कभी मंगाते हैं हम लोग पहले. ये आइए पेज नंबर 15 इंटरनल पेज 15.
दाखिल कागजात प्रदर्श A/3, A/4, A/5 का अवलोकन किया. प्रदर्श A/3 दिनांक 6/6/71 रीझो महतो का दिया गया आवेदन पर हस्ताक्षर है, जिसमें लिखा हुआ है कि श्रीमान अध्यक्ष महोदय, श्री विष्णु मंदिर प्रबंधक कार्मिक समिति सरिया प्लॉट नंबर 1600 पर स्थित कुआं से जल प्राप्त करने एवं कुआं तक जाने के लिए 4 फीट चौड़ा रास्ता प्रदान किया जाए तथा प्रदर्श A/4 जो रीझो महतो का हस्ताक्षर है, उस आवेदन पर यह लिखा है कि अध्यक्ष श्री विष्णु मंदिर प्रबंधक कार्मिक समिति सरिया ने प्लॉट नंबर 1600 के अंतर्गत जो भूमि और कुआं मुझे दिया है, उस निर्णय के प्रति मुझे देने की.
Heard the learned counsel for the appellant. The learned counsel for the appellant has referred to substantial question of law number 2 and has submitted that the plaintiff had given 7 witnesses and defendant had given 5 witnesses, but both the courts have not considered the oral evidences of the parties. He has also submitted that the matter arises out of claim of adverse possession. This appeal is admitted for final hearing on the aforesaid substantial question of law. Roman 2. That the records be called for from the concerned court upon deposit of special messenger cost by the appellant. It would be done within a period of 1 week from today. Let notice be issued to the sole respondent through the concerned police station so that the requisites for that purpose be filed within a week. Additionally, notice be issued through speed post for which requisites also be filed within a week. Office to track speed post delivery. Let the records be called for from the concerned court. Let this order be communicated to the court concerned through fax/email. Post this case on 22nd of September.
Subject to my lord's kind consideration, may I propose one more issue, that the learned appellate court has to decide the matter independent, has to give an independent assessment of the matter, being the last and final court of fact.
If the oral witnesses have not been examined and upon perusal of the records we find that they have any bearing, we'll see what is to be done. We do not know whether they have any bearing also or not. पता चले कि खाली 2 डॉक्यूमेंट एग्जिबिट कराए हैं, एडवर्स पोजीशन का कोई कुछ बोले ही नहीं है, तो irrelevant हो जाएगा ना.
From supplementary list for orders item 3, second appeal 237 of 2016.
Yes, appellant. Who is there? Yes, ये क्या है? Orders है? क्या है ये? क्या करें हम आइए? किसका सब्स्टिट्यूशन है?
5 है
अपीलेंट है कि रेस्पोंडेंट?
This is plaintiff second appeal. Plaintiff second appeal, my lord, against judgment of reversal.
Okay.
My lord, suit filed by the plaintiff. They were altogether.
No, there are so many IAs. Let us deal with that first. IA का क्या करें? IA तो करना पड़ेगा ना?
Admission नहीं था तुमको लगा.
क्या था?
This is not admitted.
Yes, it is for orders only. Substitution है. This is appeal number 83 और उसके बाद appeal number 75, appeal number 99.
My lord.
Respondent number 64.
I am sorry, my lord, I was looking.
Respondent number 49, respondent number 29. सारे में नोटिस कर.
पार्टी बहुत
एडमिट होने के बाद नोटिस जाएगा. आपको क्या लग रहा है?
Notice, man, we will take notice. Sorry, I beg.
SA number 237 of 2016. IA number 4625 of 23, IA number 5311 of 23, IA number 5492 of 23, and IA number 2933 of 24, IA number 3248 of 24. These petitions have been filed for substitution of respondent number 27, respondent number 29, respondent number 64, respondent number 49, appellant number 75, and appellant number 83. 75 भी है और 99 भी है, इसको देख लीजिएगा. एक एक में 2-2 भी है. तो अपीलांट जो आप अपीलांट होंगे उनका तो वकालतनामा फाइल कर दिए होंगे,
लीगल एड्स कर दो
ठीक है.
जी.
Let notices be issued to the proposed legal heirs and successors of the deceased respondents, and notices be also issued to all the respondents on the different interlocutory applications. They also are required to be heard
Yes.
through the orderly
My
process.
deeply.
4 weeks time
My.
to comply. Close this case on 8th December, awaiting service.
From date is for the second appeal to 325 of 2005.
Why is it fixed for orders? Submitted for hearing. Hearing है. ठीक है. कहाँ है appellant? Where is the appellant? इस पे क्या substantial question of law बना है? Yes, madam. When you are here, you answer the question. Whether the suit filed by the plaintiff was barred by section 258 of the Tenancy Act. ये तो full pen से covered है. TNT Act. बताइए. Yes, madam. बताइए. क्या रिसर्च किए? आपके फेवर का जजमेंट हम बताएंगे क्या? क्या 258 कहाँ है? छोटा नागपुर टेनेंसी एक्ट. मुस्कुराने वाली बात तो मैंने नहीं कही. आवाज तो सुने आपकी. Yes, say. What do you want? Loud and clear. I can't hear you. Louder. Who's senior? Sorry? आवाज ऊंची करिए. तो उन्होंने क्या बोला कि एक्ट मत पढ़िए. दीजिए इनको किताब, दीजिए तो इनको सेक्शन 258 पढ़िए. इस पर रिसर्च करके आइएगा. आपके सीनियर को नहीं सुनेंगे हम. कवर्ड कैसे? ठीक है. अब जजमेंट को दिएगा, उसको हमने भी डील किया है केस.
Bar to sue in certain cases. It says as expressly provided in this act, no suit shall be entertained in any court to vary, modify or set aside, either directly or indirectly, and decision, order or decree of any deputy commissioner or revenue officers in any suit, application or proceeding under section 20, section 32, section 35, section 42, section 46, subsection 4, section 49, section 50, section 55, 64, Section 61, Section 63, Section 65, Section 73, Section 74A, Section 75, Section 85, Section 86, Section 87.
Yes, pause. Section 87. इसके साथ Section 87 पढ़िएगा, full bench judgment खोजिएगा, right? Appellant absent. नाम बताइए.
Yes, Alisha Lakra.
Ms. Alisha Lakra is present on behalf of the respondents. She has placed Section 58 of the Chotanagpur Tenancy Act and submits that she shall go through Section 87 of the Chotanagpur Tenancy Act and advance her arguments on the next date. Judgment कीजिए, मिल जाएगा. कब करेंगे बताइए? 2 weeks. 2 weeks में तो हम मर ही जाएंगे तो क्या ही पता. अगला Thursday.